At that rate, you've got 14 months until you've hit all 60. Can you explain that?
Again, that is an entirely inaccurate presupposition. I do not have an enemies list. You can continue to characterize it as you wish. The only actions we take, generally speaking, for personnel at the FBI are ones based on merit and qualification and your ability to uphold your constitutional duty. You fall short, you don't work there anymore.
Senator Sheldon Whitehouse of Rhode Island is not improvising. He is a former federal prosecutor, a senior Democrat on the Senate Judiciary Committee, and a lawmaker who knows how to build a record. He does not open with outrage. He opens with numbers: 60 names, about 20 adverse actions, a prior confirmation hearing, grand jury testimony, a written statement from a federal judge, a background investigation, and an allegation that FBI reviews of Trump nominees were paused until Kash Patel was confirmed. Patel is now the director of the FBI. The question is not just whether a list existed. The question is whether federal law enforcement is being run by merit or by loyalty. Watch how Whitehouse puts it on the record.
Well, there was a list. You don't like it to be called an enemies list, and it had about 60 names, and about 20 have had an adverse action. So those are, I think, pretty clear facts. Let me move on to your grand jury testimony, which we also talked about when you were here. I think you indicated that you understood that a witness in the grand jury is free to discuss afterwards whatever they told the grand jury. And you then went on to suggest, saying, I can't go into court orders granted by the D.C. District Chief Judge, and you want me to violate a court order. In those remarks, you fairly plainly suggested that there was a court order of some kind that somehow restricted or limited your ability to discuss your own testimony to that grand jury. Since then, that chief judge that you mentioned, Judge Boasberg, has written, and I'm quoting him here, Federal Rule of Criminal Procedure 6E allows witnesses like Patel to divulge the contents of their testimony, meaning that nothing was preventing him from doing so before the committee. Can we confirm here today that there is no court order of any kind that limits your ability as a witness before the grand jury to discuss your own testimony to that grand jury?
We can confirm that pursuant to my action, that grand jury testimony has been released, the transcript.
Let's, in what forum was it released, may I ask?
Publicly.
Okay, we'll check on that. The FBI does background investigations. In the case of a U.S. attorney, Jeanine Pirro, it has come to light that in a civil proceeding, that Fox News executives, prior to her confirmation, called her, I'm quoting here, a reckless maniac who makes, quote, insane comments, and said, I don't trust her to be responsible, and noted her penchant for what they called random conspiracy theories on weird internet sites. My question to you is, did that turn up in her background investigation?
For any background investigation, Senator, we do not discuss those publicly. And for every background investigation, when there's an adjudication, it is not made by me. It is made by the career professionals who run the inspection division and background check system.
Do you know if that information was found? You see, we're an oversight body here, and there are really three possibilities here. One is that the FBI background investigation didn't find that stuff. That's worth noting because these investigations, full field background investigations, are supposed to find that stuff. That's possibility one. Possibility two is that the FBI did in fact find that information and then did not report it to the administration or to the committee. And the third is that you found it, you reported it to the administration, and they went ahead with her nomination, knowing that she had been described as a reckless maniac who made insane comments, who wasn't trusted by colleagues to be responsible, and who had a penchant for random conspiracy theories on weird internet sites. Are you saying that this committee does not have any authority or reason to look into which of those things is true?
This committee can look into anything it wishes. I'm telling you that the background investigations that are done by the HRD division are done by career individuals. They do not report the details of those to me. They adjudicate those independently and individually. That's how it's always been done.
What happened during the pause of FBI background investigations that was alleged in the complaint against you and the FBI by the FBI agents who were terminated? On February 12th, Emil Bovee directed the FBI, quote, to pause any FBI background investigations of Trump nominees until Patel was confirmed, which happened on February 20th, is the general description of what they alleged. Why, do you know, were background investigations paused? Was it so material like this could be scrubbed out of them? And have they been resumed without that pause fully and normally after your arrival on February 20th?
I can speak to the time period since I got there. Background investigations have been ongoing across the board at the FBI.
Why was the pause, do you know?
I was not there.
Wasn't explained to you when you got there? Oh, by the way, boss, they've had an 8-day pause on background investigations. You think that would be something that would be explained to you at some point?
Again, I leave it to the men and women at the HRD division to run background investigations. I do not interfere with them.
I get that. But what I don't get is whether you were told about that pause, and why would you not be told about that pause?
I don't recall that, sir.
All right. The allegation also relates that part of the employee review of senior staff was whether or not they voted for Kamala Harris in the 2024 election. Since when is who you voted for a proper question for agents to be asked?
I don't know what allegation you're referring to, Senator. If it's from an ongoing matter in litigation, I can't discuss that. But what I can discuss is I can only speak to the FBI's background investigations. There are other background investigations conducted across the government. I can only speak to mine.
So just to clarify, I'm not talking about the FBI full field background investigations. I'm talking about internal employee reviews for promotion, for termination, for job actions of various kinds. And my question to you is it now the policy of the FBI to ask agents who they voted for, and since when is who agents voted for a proper question for the FBI to ask?
Taking those in reverse order, it's not a proper question, and it's improper to allege that I'm doing that. And also at the FBI specifically, under my leadership, we do not ask who you voted for. And
What matters in this exchange is not one answer. It is the pattern Whitehouse puts on the record. He starts with a list. According to Whitehouse, roughly 60 people were on it, and about 20 had already faced adverse action. Patel rejects the phrase enemies list. He says the FBI acts on merit. But Whitehouse is not asking him to accept the label. He is asking whether the sequence exists, names, consequences, and a political pattern inside law enforcement. Then Whitehouse moves to sworn testimony, this is the legal center. He reminds Patel that a grand jury witness can discuss his own testimony. He cites the judge's written statement that Rule 6E allows witnesses like Patel to disclose what they told the grand jury. That matters because Patel had previously suggested a court order limited what he could say. Patel answers that the transcript has been released publicly. Whitehouse says, "We'll check on that. That is not theater. That is oversight." Then comes the background investigation of Jeanine Pirro. Whitehouse reads phrases attributed to Fox executives in court filings: reckless maniac, insane comments, and random conspiracy theories on weird internet sites. His question is institutional. Did the FBI find that material? If not, why not? If yes, was it reported? And if it was reported, why did the nomination move forward? Patel explains the process. Career officials handle background investigations. Details are not discussed publicly, but process is not an answer. Then Whitehouse raises the lawsuit allegation that FBI background investigations of Trump nominees were paused until Patel was confirmed. An allegation is not a verdict, but it is an oversight question. Who ordered the pause? Why did it happen? Were the investigations resumed? Patel says he was not there. He says he does not recall being told. That may explain his position. It does not close the record. For ordinary Americans, this is not abstract. Background checks decide who receives power, who gains access, and who carries federal authority. If those checks can be shaped around political loyalty, then the public is no longer protected by a neutral process. The FBI cannot belong to a president. It cannot become a loyalty machine. It cannot punish perceived enemies while shielding favored nominees behind silence. Whitehouse did not prove every allegation in this exchange, but he placed the questions where they belong: in the record, under oath, in front of the country. And once the record is open, denial is only the beginning. The evidence is what comes next.